Okay, good morning, everybody. Good morning, Ken. Good morning, Shane. Good morning, Daniel. We're going to start this up and allow people to join in. We'll give them a few moments to make sure that they're booting up properly and getting online so that we can hopefully answer any questions that they have with regards to what our topic of today is. So we'll just give it a moment or two, and then we'll officially kick things off. Just give me the go ahead, Daniel, when we're good to go. Okay, all right. Thanks, Daniel. All right, good morning, everyone. My name is Keith Moen, and I'm the Executive Director of the NSBA, Saskatoon's Business Association. And it's my privilege and honor to be with you here today. I'm excited because we have a couple of experts in their respective fields. We have Ken Dueck, the Executive Director of the Business Response Team at the Government of Saskatchewan. And we have Shane Buchanan, a labor and employment lawyer with MLT Aikins here in Saskatoon. And we've gathered these experts to answer questions for you, our membership, and those in the business community as well, that have over the past few days been in touch with our association. And we know anecdotally there are many others that have a lot of questions about what this new environment will mean for them. And so the topic of today is the mandates are lifted. What does this mean for my business? So Ken, I'll maybe defer to you, and again, as a bit of an introductory comment for you in terms of the business response team has done excellent work over the course of the past several months. Our association, I know our collegial organizations have been in touch with you as well, as have our individual members and business owners throughout the province, and you folks have done an exceptional job in managing this process and answering the questions that people have had of you. And I commend you for that work that you've done over these past number of months, and that work unfortunately is not quite done, but perhaps soon will be as we move forward into this new environment. So with that, I'll perhaps turn it over to you to provide some opening comments for us, Ken.
Sure, thanks, Keith, and thanks for the opportunity today. It's been a long pandemic for sure. For those of you who don't know about the business response team, Keith's giving you a little bit of a taste of what it is that we do. Part of our work is having the 1844 line, support for business, information for businesses and workers as it pertains to the public health restrictions that have been in place. But we've also done a tremendous amount of outreach with associations like this one throughout the pandemic to understand how folks have had to implement the public health measures. At times that's really helped influence future measures or adjustments to the measures as we understand the practicalities of the implementation of some of them. But it's also an opportunity to provide feedback and to answer questions for the membership groups as well. So definitely happy to be here today to do that. Of course, we've had a few major announcements over the last week or so. Last week, it was announced that proof of vaccination requirements in the public health order would be lifted as of February 14th. So that happened yesterday. That public health order is no longer in effect. At the same time, the government of Saskatchewan repealed the employer's COVID-19 emergency regulations. And these regulations were put in place as a temporary measure to help with some legal protection for employers who wanted to implement a proof of vaccination or negative test requirement for its employees. That was always intended to be a temporary measure, and those regulations were opt-in. They weren't a requirement for businesses, but for businesses that chose to go down that road, it provided some legal protection. With the repealing of those regulations, any protection that they provided are now also lifted. So that also happened yesterday. The remaining public health orders, Premier has announced will end February 28th. So that includes all of the mandatory masking provisions for indoor places, as well as some of the self-isolation rules that come along with positive cases will end at that time as well. In addition, one that might not have gotten quite as much attention is that yesterday the government of Saskatchewan announced the decommissioning of the business verifier app used for proof of vaccination. So this is the application primarily used by the hospitality sector, restaurants and bars and that kind of a thing, checking people's proof of vaccination. So it's the QR code reader that you could download. Anybody could download it, but it was primarily used in those environments. Because the government feels that that proof of vaccination passport system for the purposes that were outlined in our public health order has come to an end, the support for that business verifier app has ended as well. So you won't be able to download that anymore onto your phone. So if you go into the Google Play Store or the Apple App Store, you won't be able to download that one anymore. And over the next couple of weeks, it will cease to work. So that being said, I know that there are a number of businesses that were checking in another way. That will still be available. For example, SaskTel Center, if they were checking for a major event, found that the QR code reader was just too slow. So they were doing a visual check of people's wallet app and checking their ID, and that was sufficient. That was a perfectly acceptable way of checking proof of vaccination. So people will continue to be able to access their health record through the wallet app for the foreseeable future, because we know that citizens will want to travel, maybe needing to go to other jurisdictions where these things are still into effect. And of course, as of today, still you're required to have that for air travel within and outside of Canada. So those will continue to be accessible. So that's kind of where I wanted to introduce. I know there are a number of questions, but I think Shane has some introductory remarks as well.
Thanks, Ken. As Keith said, I'm Shane Buchanan. I'm a labor and employment lawyer for MLT Aikins in Saskatoon. Feels like I've been more of a COVID-19 lawyer for the past 2 years, and in the past several months, really a vaccination lawyer. That takes up most of my days lately, with the past several months implementing policies and now dealing with these recent changes. So thanks, Ken, for that great summary on what has actually changed yesterday. That sets the stage nicely for our discussion today. So to start out, I'm just going to give some high-level comments regarding on what has changed from a legal perspective, and then we can open up the floor for some questions. I think we'll get the most out of this session through our Q&A period, but hopefully I can knock down some of your questions in my opening comments. And before getting into that, I just want to give a quick disclaimer that my comments are intended to be general in nature and not exhaustive. Also, as we all know very well right now, legislative changes and government announcements and other developments are frequently taking place with respect to this pandemic. So things change rapidly, and something I say today may not be true in a few weeks if there's another change. So just be aware of that as well. And I recommend that if you're looking into any sort of specific situation, that you do seek legal advice on that situation. So in my view, there are two different categories of changes that we need to recognize. The first is the removal of the public health order, which mostly refers to requirements that businesses can impose for the general public, so for your customers, and not focused on employees. So this is what the removal of what is commonly referred to as the vaccine passport system. The public health order also refers to masking requirements and isolation requirements, as well as a few other issues. Secondly is the removal of the COVID-19 emergency regulations for both public and non-public employers. The focus of the regulations was on the vaccinate or test requirements for employees. So this second category is focused on your workforce and not related to the general public. And so when I refer to a vaccinate or test policy, which I'm going to refer to a few times today, I just want to be clear that I'm referring to the vaccinate or test policy that was permitted under the regulations that have been appealed, which is where employers could require employees to provide proof of vaccination or undergo regular COVID-19 testing at least every 7 days on the employee's own time and at their own expense. So those have been appealed as of yesterday, but that's what I'm referring to when I say vax or test policy. So as a starting point, the removal of the public health order and the regulations does not necessarily mean that employers must also discontinue their vaccinate or test policies, remove their vaccine passport programs, or their masking requirements. It's not an automatic that you need to remove those things, and I'll work through those here in a moment. So I'll start by discussing the public health order, which removes the vaccine passport system for customers and the masking requirement. Businesses generally have wide latitude under the law to create and implement customer policies and rules, and to deny entry or refuse to provide service, provided that those policies are not discriminatory on the basis of protected grounds under human rights legislation. Since the start of the pandemic, many businesses have required customers to wear masks, even when they weren't required by the public health order. Many businesses have required patrons to sanitize their hands before entering the premises. Outside of the pandemic context, businesses may require patrons to adhere to a particular dress code, or may prohibit the carrying of large bags or backpacks on premises. The classic example may be the no shoes, no shirt, no service policies that can be found on some signs in some businesses. So provided that these rules are implemented in a non-discriminatory manner, there is no legal prohibitions on making policies for patrons. So if I want a store and I want to require the vaccine passport, if I want to require masking, if I want to make a requirement saying only people wearing blue shirts can enter my store, employers have that right so long as it's not discriminatory. And it's a different question whether it's legal and whether it's good for business. I'll leave those business decisions up to individual business owners, but I'll speak on what I view as legal and not legal. The law with respect to the vaccinate or test policies for employees is a little more complicated than the vaccine passport and masking. So employers will need to conduct another risk assessment of the impact and safety concerns by COVID-19 in their workplaces in light of these changes and the current phase of the pandemic. Risks with respect to business continuity should also be considered. If employers wish to continue with their vaccinate or test policy, they will need to be able to justify that such a policy is a reasonable health and safety measure in the circumstances. Part of this assessment will include how bad the spread of COVID-19 has been in the workplace to date, and how effective the policies and practices have been in supporting a safe workplace. So if the other measures you're taking, such as distancing, masking, have been really effective, then perhaps a vaccinate or test policy isn't justifiable in your workplace. On the other hand, if those policies aren't working and you're having outbreaks, then perhaps a vaccinate or test policy is necessary. Also, it's important to note that employers will be back in a similar position to where they were before these additional legislative protections were in place, namely spring and summer of 2021, when vaccinations were rolling out and vaccination policies were first implemented. I had several clients that implemented vaccinate or test policies before these regulations were put in place. An employer didn't need the regulations in the first place, and they didn't necessarily need them now. When we did get them and we had employers who had them in place, we said, great, we've got extra protection now. This is great to have, but we didn't necessarily need it. The difference now is that there is additional information in place regarding the efficacy of vaccines, as well as some arbitration jurisprudence upholding vaccinate or test policies in the workplace. We're also now dealing with a more transmissible but less severe strain of COVID-19. The pandemic has changed, but employers shouldn't be too quick to throw out their existing practices. it may be worth sitting back and assessing over the next number of weeks what changes could be made to the safety measures in place. And in that context, I want everyone to remember that first and foremost, employers have a legal obligation to ensure the health and safety of both the workers and patrons of their business as far as reasonably practicable. Employers are permitted to do better than what is required in the legislation with respect to safety measures. As a result, employers will need to assess the level of risk with respect to safety measures. Any particular vulnerabilities of workers or patrons as a result of COVID-19 complications will also need to be considered. A vaccination policy should take into account the level of risk in different service areas and only implement the measures necessary in each context. So it may be possible that requiring staff vaccination or testing is reasonable in some service areas, but not others. For example, if your business works with a vulnerable population, perhaps it makes more sense in that environment than it does in an office setting where everyone's, closed door, separate area. So the nature of your workplace could be important in the assessment. The assessment has always been and will continue to be to determine whether a vaccine or test policy is reasonable. It becomes even more important with the lifting of the public health order and legislation condoning vax or test policies. While the legislation was in place, it provided an argument for employers that the vax or test policies were reasonable in the circumstances. This could still be established depending on the workplace, but it'll require a more in-depth analysis and justification. You can't just lean back and lean on these regulations. We don't have them anymore. You're going to have to do your own analysis and have your own justification for implementing such a policy. I also want to note, I think this is really important, is that employers in other provinces have implemented vaccinate or test policies without public or private employer regulations that we had in Saskatchewan. From my understanding, Saskatchewan was the only province that had these regulations. So we were really lucky to have them. And now that we don't, it doesn't mean we necessarily need to get rid of our policies. We've also seen several case law decisions from jurisdictions that don't have the regulations where the reasonableness of a vaccinate or test policy was upheld. We've seen cases in Alberta, several in Ontario. We haven't seen them in Saskatchewan, and my opinion is that's likely because of the regulations. It would have been very hard to challenge such a policy because an employer can say, look, as long as the employer was following the regulations and not doing something outside of them, it was very easy for an employer just to point to those regulations, say, look, we're following these. And I think most employees and unions probably wouldn't have challenged a vaccinate or test policy on that basis alone. That doesn't mean if they are challenged in the future, they'll necessarily be upheld. But I think it's important, and I think an arbitrator would likely look to other jurisdictions to see what's being decided in an area where there is no regulations in other provinces. So based on these considerations, as a first step, employers will need to assess whether they wish to continue with their vaccinate or test policies and other COVID-19 safety measures in light of the changes yesterday. If so, employers should clearly set out in their assessment what protection the policy is providing that cannot otherwise be provided by other safety measures. So a vaccinate or test policy or a vaccine passport system shouldn't be your first line of defense. You should be looking at other safety measures first and see whether those are effective at stopping the spread of COVID-19. If they're not, then a vaccine passport system or a vax or test policy may be necessary in your workplace. If an employer simply decides to discontinue a vaccinate or test policy just because the public health order is gone or the regulations are gone without consideration of safety implications, an employer may be at risk of failing to fulfill their occupational health and safety obligations to provide a safe workplace. As a result, these decisions require careful consideration and analysis and should not be made lightly. So those are my general opening remarks. Unless Keith or Ken have some other remarks, I think we'll move into our Q&A session.
Well, thank you very much, Shane. We have had a number of questions come in, and I should have mentioned off the start that for those attending today's webinar, if you do have questions for either Shane or Ken, please use either the chat function or the Q&A question function as part of the webinar package, and we'll get to those questions as we move along here. And thanks to everybody for attending again today. We have a good number of people on the line, and I know a lot of them have questions with regards to the topic of the day. I guess, Shane, you obviously went through a lot of information, and I know that you addressed this already, but just for clarity's sake, so let's just talk about in terms of legality. If someone wants to require passports, whether it's a retail business, for a patron, or if it's a business-to-business organization that has employees and they got their policy in place, what's the legality of that if someone were to challenge the business owner based on that policy? Where would that legality lie?
Thanks, Keith. And yeah, and I think this is probably a popular question, so it's worth reiterating. And I want to be clear that employers have very, very wide latitude with respect to the rules and policies that they implement for their business from a legal perspective. Sometimes those rules may not make sense from a business perspective, but from a legal perspective, you can implement a vaccine passport system or masking requirements so long as you do not do so in a discriminatory manner. So if you choose to put a vaccine passport in, and a customer comes and says, here's my medical note, I have a legitimate exemption for a vaccine, and you turn them away, that is potentially discriminatory and offside the legislation. But if you make a reasonable accommodation for them, then that is in line with your requirements. So a business owner has wide latitude. They can implement those policies.
Okay, thank you. Ken, do you have anything to add to that question at all, or?
No, not on that one, thanks.
Okay. Let's play out a scenario now. We have a number of contractors within our association, and then we have scenarios where there's the owner, of course, whose job it is, and then there are the contractors, the general that does the job, and then there are subcontractors on site as well, and of course employees of all of those folks on site. And then adding more complexity to it, if it's a say federally regulated industry, or even if a federal crown corp, which may have different rules than what our province of Saskatchewan currently has in place, or certainly March has different rules. Where is the liability with that? Who's able to make the decision as to what policies or mandates are in place, and who will be liable for any challenges that might be forthcoming from such a scenario?
Thanks, Keith. So the way I understand the question is, let's say, for example, you have a business owner, federally regulated, and they implement some sort of policy, perhaps mandatory vaccine, get vaccinated or you can't work on our site, or even a vax or test policy. And then you're the client that wants to attend that site, or you're the subcontractor and you want to attend that site, and some of your employees aren't vaccinated, so they can't. So who does the liability fall on? My first question when I hear that question, my first response is, what liability? What are we really talking about here? For your employees, potentially there's a human rights issue if they have a legitimate medical exemption or a religious exemption. The other potential liability for your employees would be constructive dismissal. They claim because they can't attend the site, they would be constructively dismissed. So that's really the only potential liability I see. As a contractor, you have to comply with the requirements of the site, regardless of whether you like them or not, or think they're legal or not. So for example, if you're dealing with a federally regulated employer, they may have a legal right to implement a mandatory test or mandatory vaccination policy. They don't have legislation on that yet, but there's been a call to provide feedback on such legislation. So I don't think, as an employer, as the contractor or subcontractor, you're incurring liability because you have to comply with those rules. That being said, you need to be careful with how you deal with your employees and how you address the situation. So for example, if you have an unvaccinated employee and they don't have a medical exemption, they don't have a religious exemption, they just say, look, personal choice, I don't want to get it, I don't want to be forced into that. You say, okay, I understand that, but it's a requirement to be on this site. We'll work with you. Perhaps you can work for a different client. Perhaps you're going to have to be put on an unpaid leave until this subsides. So I would really deal with that in the same way you've probably likely been dealing with it up until now. And I don't expect liability on the part of either the owner or the contractor unless something's handled in an inappropriate way. If an employee launches a complaint, I mean, your hands are tied really in terms of what the owner is requiring.
Right. Okay. Thanks, Shane. How about Ken? Do you have anything to add to that on that one?
No, I think Shane's handled that one fully. I don't have anything to add on that one either.
Okay, thank you. I see we do have some questions filling up some of the chat function. So I'm going to ask the question from Jim Mojeski, and Jim asks, what about the employees who have lost their jobs due to their vaccination status? Do we need to hire them back?
So I have a couple comments on this. One is I would be curious why they lost their jobs. Was this a mandatory vaccination policy and they just decided not to, or a vaccinate or test policy and they decided not to? But from my understanding, and perhaps Ken can comment on this, if you implemented a policy in accordance with the regulations, so a vax or test policy, under that type of policy, an employee didn't have to get vaccinated. They had the choice, get vaccinated or undergo testing. So if they were terminated, my assumption is they probably were terminated because they refused to test or something like that. And the regulations provided protection for that at the time when that termination would have taken place, and they will still provide protection for any action that was taken within that time period. So if they were terminated today, the regulations are appealed and would not provide protection. But if that happened months ago while they were in place, you would fall under protection. So I don't think there's any legal obligation on an employer to rehire any of those employees at all. And I think you keep the status quo. That being said, if on a voluntary basis, you want to bring some of those employees back, I think employers should feel free to do so.
Okay, thanks, Shane. Ken, anything to add on that one?
No, again, I think Shane's handled that one very well and accurately. So really don't have anything to add on top of that.
Okay, great. I'll move to a question from Bridges Health, and it says, stepping back from the passport/vaccinate policy, would a production line style company be on a slippery slope if they're to mandate a weekly negative test policy for business continuity purposes? So obviously they're just trying to, maintain a safe and healthy workplace for their employees so that possible contamination would not take place in the workplace.
Right. And I understand the question, and part of it is going to depend on the specifics of that workplace. My question would be, have the measures to date been effective in stopping the spread of COVID-19, whatever those measures may be, including, masking, distancing to whatever level is necessary? I assume by saying it's a manufacturing that there's probably an implied notion that these employees work closely together with one another, so distancing may not be possible. That being said, I don't see any reason why an employer cannot undergo weekly testing. My question again would be, okay, now is it take-home testing that's provided free of charge, or are you going to require them to go pay and get a third-party test? Those are important considerations, and it comes back to the employer needs to justify that other safety measures are not meeting the duty to keep a safe workplace. So you could even have two identical companies, or the exact same company with two different branches, and for whatever reason, your safety measures are working effectively in one and not the other. So it's not even necessarily always related to the industry. Some healthcare industry employers may need further measures, and some healthcare may not. So it is really an individual analysis.
Yeah, go ahead, Ken.
I'll just maybe add to that one, and I might be kind of putting myself out on a limb here a little bit, but I sit in on the technical briefings with Dr. Shahab sometimes a couple of times a week. And one of the things that has prompted our change in provincial government policy as it pertains to how we're dealing with, in particular, the Omicron wave of the COVID-19 pandemic, is that the virus has changed over time. And so while vaccinations and boosters were extremely effective with preventing illness, but also reducing the spread of previous waves of COVID-19, especially Delta and the UK strain as well, it has proven to be less effective at preventing the spread of Omicron. Omicron has just proven to be so much more transmissible. And that may play a factor in your risk assessment as well. As Shane rightly said, you have to demonstrate that the measures are going to be effective, and that the current measures that you have in place aren't being effective at preventing that particular spread. So that may become more challenging with the transmissibility of Omicron. But I don't know, Shane, if you've had any kind of conversations around the shift in the nature of the illness that it is that we're having policies to try and prevent spread in the workplace.
Yeah, thanks for those comments, Ken, and I agree. And this is where defending a policy can get complicated and expensive, because if you are challenged on a policy, say by your union or your employee, you're likely going to require medical evidence, a medical expert to justify the policy. And I can't speak. I think it's well documented that the vaccines are not working as well as they once did, but they're still reducing transmission to a certain extent. How effective they are is an important question, and one I can't answer. And you may need, a medical expert to defend your policy if you're ever challenged. So just keep that in mind, that that's an important consideration and an expensive one, and one that changes. I hate to even mention this, but there is the potential that we see future variants. And I know nobody wants that, but it is a reality. And perhaps a future variant is more severe, and maybe the vaccines work better for it, maybe they work worse. So we just have to be alive to those issues. And that's important. If you are going to remove a policy or keep your policy, just be alive that the removal of the public health order and the regulations doesn't mean COVID-19 is over. It means we're shifting to living with this. But things could change as we've seen over and over again the last 2 years.
Okay, great. Thanks to you both. In the Q&A, we have a question from Hanif Hamani, and Hanif is wondering, if a policy is implemented and a worker refuses to comply due to medical exemptions, are they required to disclose that medical condition, or how do you know it's a valid refusal of compliance to that policy?
All right, and that's a good question, and that's something we were dealing with frequently over the last few months when these policies were first rolled out. So sometimes you'll get an employee has to provide medical documentation supporting their disability. Sometimes you'll get like a one-liner note from a medical doctor, and usually that is not sufficient. An employer does not have a right to know the diagnosis, so exactly what's wrong, but you do have a right to know a lot of information, such as prognosis, what accommodations could be made, whether this is a temporary or permanent situation. For example, some medical conditions are temporary if they're just dealing with some repercussions from some sort of procedure or something like that. Perhaps it's only temporary and they don't need it in the future. But an employer has the right to ask for more medical documentation, including you should confirm that the employee is in a doctor-patient relationship with this doctor. So it isn't some doctor from a different jurisdiction or some doctor they just found online. This needs to be a doctor-patient relationship. You also need to make sure that the doctor has done some sort of assessment. You don't get to know the details of that assessment, but you need to know that. So it's not as simple as saying, okay, here's a one-line doctor's note or some generic note from another jurisdiction, and then you accept that. It needs to be a valid medical exemption. And in my experience, those are very rare. They exist, but they're rare. So I wouldn't accept a doctor's note right on the face of it unless it meets all of those requirements.
Okay, thanks, Shane. Anything to add on that one, Ken?
Again, I think Shane's handled that one really well. I agree. listening to Dr. Shahab talk about the things that would truly disqualify somebody from getting the vaccine from a medical perspective is very small and very rare, and it is a pretty hard thing to come by, but it's not impossible. And those things do exist, but I think Shane's given some really good advice there.
Okay, great. Thank you. I see a couple more questions, one in the chat and one in our Q&A. So in terms of the chat one, I'm just going to read through it, make sure that we have not yet answered it. But beyond COVID, it is foreseeable that some businesses may be compelled to want to require proof of seasonal flu vaccine, for example. Can you speak to the implications of that or comments around that?
Yeah, I can speak to that. So that's actually an issue that's already been dealt with in our legislation. A number of years ago, there was many employers that implemented that, including, I believe, the former Saskatoon Health Region, who went through a pretty noticeable dispute with their union on whether those required. And so there's a number of cases regarding, at that time, it was get the flu shot or wear a mask. Some people may recall that. And the outcomes in those cases varied. In some cases, the flu shot policies were upheld, and other they were denied as unreasonable. It really depends on the specifics. And in those cases, what we found that was really important in the cases where they were upheld was the employer had a medical expert that justified the use of the flu vaccine. And you also have to show that other measures aren't meeting the requirement to keep employees safe. So I sort of have to give a vague answer on that. It really depends on the specifics. Medical experts will be important, and you'll want to review those case law decisions to see where your employer, where you align with the other decisions. I also want to be clear that you need to ensure any type of policy you implement is focused on safety and is not punitive based. For example, I had an employer call me back when the mask restrictions were lifted, and they said, we want to implement a vaccinate or mask policy for anyone who isn't vaccinated at all times of the day, including when they're in their office and the door is shut. And I said, well, is that really in the interest of safety, or is that punitive based? Because I'm not the medical expert, but is there a medical reason why someone would need to be in their office, door closed, not around anyone else, wearing a mask? And I don't know if that's supportive. So just remember that is the point here. We're focused on health and safety, and punitive measures should be avoided.
Okay, thanks, Shane. Ken, anything to add on that one?
That's a really good point, Shane. And I guess I would say that, there were a couple of reasons for implementing the proof of vaccine mandates in the fall of 2021. One was that at the time, we knew that the vaccines were very effective at particularly combating the Delta wave. And by implementing a proof of vaccine mandate through the public health orders and enabling employers through the employers' COVID-19 emergency regulations to implement proof of vaccine or negative test in the workplace, it would increase our number of people in Saskatchewan who were vaccinated, and it did that. It did increase our vaccination rates, and so it was quite successful from that perspective. And so sort of the second reason was to create safe environments for things so that we could keep certain activities open, including our restaurants and other hospitality sector businesses. Due to the changing nature of the pandemic and the evolution of the virus, the government of Saskatchewan has deemed that risk in terms of providing a safer environment for things like restaurants and bars and the workplaces as not as severe. And so that's for one of the reasons for removing the mandates now. So essentially, the determination is that the benefits don't outweigh the risks anymore. for that regime to continue on to be in place. And so that's why it's being removed.
Okay, great. Thanks, Ken. We don't have another question in the Q&A portion. So it says, currently a positive infection with COVID-19 requires a mandatory 5-day self-isolation period. After the masking and vaccination passport mandates are lifted, do you think that the province may move to a, quoted air quotes, recommended isolation period versus a mandatory one?
Yeah, I can take a first crack at this one. It's probably a bit of an unsatisfying answer. It's I think something that's under consideration in terms of what that guidance is going to be. What I can tell you is that isolation provision will be in place until the end of February. I think it's a reasonable question in terms of what the recommendation will officially be. I can speculate a little bit in terms of what I think, the Chief Medical Health Officer might say about that. But I think we should stay tuned a little bit in terms of what that official guidance is. Generally speaking, though, I think it will remain the case that we would encourage people to stay home when they're ill. I think that the general workplace tolerance for coming to work and toughing it out when you've got a runny nose and a cough is probably gone. The other employees probably don't want you around, and your employer probably doesn't really want you around because they know they're going to be losing people to sick time if you're coming in when particularly you're symptomatic. So I think that's just sort of a reasonable approach that we can kind of look forward to. But I think that there will be likely some stronger statements from Dr. Shahab and the Premier in the coming days as we get closer to the end of the month.
Okay, we'll look forward to that. Shane, anything to add?
I think Ken did a really good job there of outlining, what's going to happen in the future here. What I'm advising clients is to be prepared for the reality that isolation requirements are going to be gone at the end of this month. And likely we're going to see something that's, encourage employees to stay home or individuals to stay home if they have symptoms or if they're testing positive on a rapid test. To me, the question becomes, as an employer, can we require employees who are showing signs or symptoms or who have tested positive on a rapid test or another test to stay home and to isolate? And that's going to be a very important question going forward. And I think the starting point is we need to differentiate from staying home from work and isolating. As an employer, I don't think you'll ever have the right to require an employee to isolate. You have the right to say, you're sick, stay home from work. But you can't say you have to stay in your house. You can't go get groceries. You can't go pick up your kid from daycare. As employers, you don't have a right to direct employees what they do on their personal time. But if they're showing signs and symptoms, I think employers do have a right to say, stay home, wait until you're symptom free, and then return to work. There's some concerns that go along with that, such as whether that's sick leave and whether they're entitled to pay. I think anytime an employer is directing someone to stay home, that employee is entitled to sick pay. And I just think there's going to be a much different shift, and we've probably already seen it around sick time and sick pay. And like Ken already said, the days of toughing it out and having the employee that went 20 years without a single sick day, I think those times are gone. People are staying home more frequently. It's great if you work in an environment where people who maybe are feeling just a little under the weather can still work from home. If that's not an option, then I think employers need to have a serious conversation and discussion about how sick pay and sick time is going to work going forward, because I see it increasing.
Okay, answered the question I had in my mind. Just in fact, if you had seen the number of cases of private employers providing sick pay, that let's face it, is pretty uncommon in the workplace, but is now becoming more commonplace, you're suggesting, Shane?
In my experience, I have seen an increase. Because it is a reality. Nobody wants to work with a person 10 feet away who's coughing and sniffling, whereas before no one really wanted to either, but people weren't making a big stink about it 3 years ago. It was just a different landscape. So I have seen an increase in that. Great.
Okay, thank you. I'll just remind everybody once again to use either the chat function or the Q&A function if they have questions for our panelists. We have about 15 minutes left in our webinar today. So if you're wondering if they're going to get to what you have in your mind. I'll encourage you once again to use those functions to present your question to these folks. We did do some rounds of questions amongst some of our members beforehand as well, and so we have some written ones, and maybe Ken, I'll turn to you, and even though it's largely outside your jurisdiction, because I think a lot of the programming that was in place in terms of funding and emergency relief came in the form of federal funding, but there was a question that came in that said, I think there may be confusion over the status of the federal support as it relates to staff, and so the CEWS or Qs and the rent subsidy. It has changed quite a bit from quarter to quarter, which it has, the rules and applying and whatnot. So clarity on where that stands, and if there will be any other type of support available after March would likely be of interest to many on the call. So Ken, can you address some of that?
Sorry, I was on mute there. I can speak to a certain degree. I know there was some concern, particularly over the last month or so, where the Government of Canada instituted a couple of programs that, for the most part, Saskatchewan businesses and workers weren't eligible for because we weren't under capacity restrictions that were in place in other jurisdictions. And those were the local lockdown program and the Canada Worker Lockdown Benefit. That being said, Saskatchewan tourism and hospitality businesses with a revenue loss of 40% or more may be eligible for wage and rent subsidies under the Tourism and Hospitality Recovery Program. So that's the Federal Tourism and Hospitality Recovery Program. And Saskatchewan businesses of any sector with a 12-month average revenue drop and claim period revenue drop of at least 50% may be eligible for wage and rent subsidies starting at 10% under the federal hardest hit business recovery program. There are a number of other things through Prairie's Can that are largely debt related programs that have been available. I do recognize that these have changed and adapted over the last year and even number of months, and it can be difficult to kind of wade through those. We do have links to all of those programs on the Support for Business website, direct link to the Government of Canada page with all of the application information for all of those programs. But I do recognize it can be challenging to wade through all of those and determine whether or not it's worth your time and effort to apply for those programs. But that being said, my experience with the federal officials on these programs is that they want to provide the support. They're not trying to find ways to say no, generally speaking. They're trying to find ways to say yes. That's certainly how we tried to operate our programs. I know it hasn't always been the case, and not everybody has been able to qualify for the programs that are there. But that has been, I think, the general attitude. We do have one program available that's somewhat in response to the pandemic, and that is the Reskill Saskatchewan Training Subsidy. So this is a bit of a companion program along with the Canada Saskatchewan Job Grant. And there is lots of information on our website about that, but it's to help employers train employees, especially as they recover from the economic shock that has been the last 2 years of the pandemic.
Great, thanks, Ken. Shane, I'm assuming you don't have much to add on that, or maybe I'm wrong about that.
No comments from me on that.
Okay, all right. We have a question on our chat function from Lee Whittington, who's wondering, states one of the specific restrictions affecting restaurants / hospitality venues was the stopping of live music and in the place of business. Does the February 28th removal of the final health order automatically allow entertainment at all venues, or will there be some other type of restriction associated with that?
So we haven't had a restriction on live music for quite some time. That has been able to proceed even under our proof of vaccination system. One of the reasons for implementing the proof of vaccination system was so that these venues could remain open. Now, that being said, I realized that particularly music performing artists haven't been touring because not every jurisdiction has been open to allow these types of performances. But we haven't had capacity restrictions at performance venues since July of 2021. That being said, many other jurisdictions have, and so lots of touring artists haven't been coming through as a result. I know Connexus Arts Center, just for example, I don't think has any business in February at all in terms of those performing arts. So it has been a very highly affected sector, but it is not restricted in Saskatchewan at this time. And now they are also not required to check the proof of vaccination for those venues as well, but they can operate at full capacity, and those live performances are able to proceed.
Okay, thank you. I guess that brings a question to my mind too, Ken, in terms of, we have certain performers that come in and they implement their own policy with respect to vaccinations and so on. I actually don't know if the Foo Fighters have announced what their expectation is. So are we expected to see some, back and forth in terms of some performers requiring certain restrictions or mandates or what have you, and others not? Will that be a part of the future?
Yeah, thanks, Keith. I actually did a session very much like this with some of our major entertainment facilities on Monday because of this very reason. I was aware that we had a major concert announcement coming yesterday, and of course that was the Foo Fighters, which is a stadium filling act, and we certainly want to send a message that Saskatchewan is happy that these major touring artists are touring again in Saskatchewan and seeing Saskatchewan as a profitable destination for their acts. That's going to go a long way in the recovery of the hospitality sector in Regina and Saskatoon, filling all those hotel rooms for those nights and keeping the restaurants and bars busy for the days surrounding those events. But we also recognize that these touring artists are touring multiple jurisdictions, not just in North America, but in Europe as well. And they may want to have things in place that are safety measures for their performances. And I think one of the things to understand here is that the entertainment sector has been one of the most highly affected by the restrictions, capacity restrictions, and restrictions on people's activities that were deemed to not be essential. And so they're naturally a bit cautious about proceeding. They're a little bit nervous about, what the future might hold, what future strains there might be. I think it's understandable that they're taking a cautious approach and perhaps wanting to have measures in place and be able to do that, even if in the jurisdiction that they're operating in, that's not required at the time. The Foo Fighters concert is a good example. I mean, it was announced yesterday, the very day that we removed proof of vaccination requirements. So it's interesting timing on that sense. But the concert isn't until September. And, the situation could be very different between now and then. I don't have a crystal ball in terms of how this is going to evolve, and it could be very different from that time. So, at this time, I think those are business decisions between the venue, operator, the promoter, and the artist, and they need to be able to do their risk assessments and engage in their contractual arrangements appropriately.
All right, thanks, Ken. Shane, anything to add there?
No, nothing to add.
Okay. Just one final reminder about if you have a burning question that you want to get to either Shane or Ken, please enter it now, because we're down to about 5 minutes left or so before we're going to wrap things up. But going back to the questions that we had sent to us beforehand, and we haven't talked a whole lot about masks, but I do have one that came in regarding masks. And so it's saying, can businesses require that customers, so it's a customer facing business, wear masks when entering their business? And then I guess furthermore, what happens if if they are doing that policy and customers refuse to do so, what can the business do? And then I guess just to add one more layer of complexity to that would be could the business expect any form of support from either or the government or even law police forces?
Sure, I'll take a first crack at that one. And Shane, you might have some things to add after I comment. This is a really important question and a very common one that we're getting on our support for business 844 line is what can we do kind of post masking public health order. And I think Shane's laid out fairly well that, a business can require a lot of things for patrons coming in. And so long as it's not discriminatory, you can continue to ask for things like wearing a mask. Frankly, I think you can probably ask for somebody to wear a hat with a propeller on it if you really wanted to. But that's being a bit glib. If you wanted to, though, ask people to wear masks, there are a few things to consider. When there was a public health order, it was a requirement. There was a law that said that you had to do this in an indoor space. And if you weren't doing that, you could face a fine and a ticket. And that did happen on occasion. We did have the COVID enforcement team that was out there, as well as the public health inspectors that were empowered to issue tickets to people who weren't wearing masks. And there was a bit of a shared responsibility between the business owner and the person to be compliant with the public health order. Without the public health order in place, that enforcement support does cease. There won't be any tickets issued for people not wearing masks. There won't be any kind of that type of enforcement for a business in implementing a policy. And I will say that, especially in the retail environment, businesses had a challenge enforcing this while there was that support in place and while there was a public health order in place. Frontline staff did a good job for the most part of, not being confrontational. If somebody came into the retail operation and wasn't wearing a mask, the best practice was to be able to have masks on hand, to offer the person a mask, to kindly ask them to put them on, to remind them that it is a requirement in a public place. And if they chose not to, offer them service in some other way and accommodate them through curbside delivery, or what is it that you've come in to get today? We can go and get it for you and conduct payment outside the facility, something along that line. The challenge comes what do you do when somebody says, I don't want to do that and I still want to come in? How are you going to deal with the escalation of that situation? How are you going to instruct your staff to deal with the escalation of that situation? And what do you do if somebody refuses to leave your premises? Well, at that point, they are trespassing. You can call law enforcement at that time. But I do want to caution you around that calling law enforcement for somebody not wearing a mask in your business is probably not at the top of the priority list for the police that day. So the response time for a call like that might not exactly be super fast. And so unless your employee is in imminent physical danger, that might not be a great response. So these are just sort of the types of things that retail, in particular operations, have been kind of dealing with throughout the pandemic and having to work themselves through. Removing the requirement to wear masks does change that. It becomes very much on the business owner to be implementing and dealing with potential escalation issues as they may arise.
Okay, thanks, Ken. And Shane, maybe I'll just ask you to be brief because we have one other question that came up in the chat, which I'd like you to address as well. And that's going to take us a little bit beyond our 1 hour time frame. But I'll see if you have any questions or comments with regards to the mask situation firstly.
Yeah, I agree with Ken. Yes, you can impose masking policies subject to human rights concerns. 2, if somebody doesn't want to, you can ask them to leave. They are trespassing. And 3, you should rely on the police to remove that person. The police should treat that as any other person who's refusing to leave for any other reason. For example, you have a customer that gets upset because you ran out of stock of their favorite product and they're being aggressive towards your staff. Say, please, sir or ma'am, leave our premises. You're now trespassing. And if they refuse, you call the police. I think Ken pointed out some good practical considerations, but from a legal perspective, that's how it should work.
Okay, great. Thank you. And final question goes to Michelle, who's wondering if an employee is ill and should not be at work, but they do not have the ability to work from home. Is it legally required for an employer to send that employee home with pay?
That's a really good question. Partly it depends on your sick leave policy. So if you have one, you'll want to review your policy. Another issue to deal with that is I've had clients raise concerns about potential fraudulent use or misuse of take-home tests in order to exploit sick pay. So somebody takes a take-home test, it shows positive. There's no way to verify the accuracy of it. My advice to employers is require an employee to get a third-party PCR test, and then you'll determine whether they have COVID-19 or not, and then that determines whether it's paid or not. The same way, in many instances, you require an employee to get a doctor's note to provide documentation regarding an illness.
Okay, thanks, Shane. Ken, anything to add on that one?
Oh, nothing further to add on that.
Okay, great. Thank you. Well, I see we're just beyond our 1 hour time frame. And so with that, I'm going to wrap up and thank you both very much for your time and more so for your expertise. It's been invaluable to all those on the call. And we do have this recorded as well, and it's available on our website. So if those that are on the call know of colleagues or associates that they would like to see this information, by all means, they can log on to our NSBA website at nsbasask.com, nsbasask.com. And would obviously have that there. And any other questions? And I'm assuming Ken and Shane, we talked about this a little bit beforehand, you'd be open to questions that would be coming from the membership as well. So best ways to reach each of you, if you don't mind.
Yep, for sure. You can reach the business response team at 1844 line. And Keith, you and Daniel have my direct contact information to pass people on directly to me. And I've got Larry Wells on here on the call with me as well, who's been very helpful to many of you throughout the pandemic as well. So a number of ways to reach us. Thanks again for the opportunity, and happy to help provide a few answers, and happy to help work through a few issues with businesses as well as they kind of get through some specific situations.
You bet. Thanks, Ken. And Shane, the best way to reach you?
Yeah, you can pass on my contact details for those that don't have them. Probably just easiest to Google Shane Buchanan, MLT Aikins, or go to our MLT Aikins website. My email and phone number on there. Feel free to reach out to me either by email or phone, whatever works best. I'm happy to answer questions, particularly any questions that we didn't have time for today.
Okay, great. Well, thank you. Once again, thanks everybody for attending. Hopefully we'll see you live and in person. We accommodated this webinar just because of the timelines involved. We wanted to get this information out to you in a very quick and expedient way. Our next live in-person event is on, help me out, Daniel, March 1st. March 1st, we have Brent Penner talking about It's Got to Be Downtown. And I think that he's going to be touching on largely the downtown entertainment and event district. And we look forward to that presentation at that time. So again, Ken, Shane, thank you very much. And have a great day. And we'll see you again soon.
Take care.
Thank you.
Thanks.
Thank you. Bye-bye.